Thinking about filing a small claims case in California, here's what you need to know. Small claims court is designed to help people resolve money disputes quickly and without a lawyer. It's meant for cases involving $12,500 or less for individuals and $6,250 or less for businesses. If you're suing for more than these limits, you'd have to give up the extra amount or file in regular civil court. Step 1. Filing your case. To start your case, you need to fill out a form called Plaintiff's Claim, SC-100. You'll file this at the Small Claims Division of the Superior Court in the county where the defendant lives or the issue happened, for example, where a contract was broken. You can usually file online, by mail, or in person. There's a filing fee based on how much money you're asking for. $30 if you're suing for up to $1,500, $50 if suing for $1,500 to $5,000, $75 if suing for $5,000 to $12,500. Once you file, the court gives you a trial date, usually within 20 to 70 days. Step 2. Notifying the defendant, serving papers. The person or business you're suing, the defendant, must be notified about the lawsuit. This is called service of process. The court won't hear your case unless the defendant is properly served. Someone other than you, who is at least 18 years old, must deliver the court papers. You can hire a process server, a professional who delivers legal documents, the sheriff's department for a fee, or a friend or family member, as long as they are not part of the case. Once the defendant is served, the person who served them must fill out a proof of service form and file it with the court. Step 3. Mediation, if required or optional. Some courts may require mediation before trial. Even if it's optional, mediation can help you reach a fair settlement without going to court. A neutral person, a mediator, helps both sides talk and try to find a solution. If you agree on a settlement, you don't need to go to trial. Step 4. The small claims trial. On the day of the trial, arrive early and bring all evidence to support your case. This can include receipts, contracts, invoices, emails, text messages or letters, photos or videos, witnesses who saw what happened. They should come in person. Both sides will get a chance to explain their case. The judge may ask questions, and then they will make a decision on the spot or mail it to you later. Important: if you are the plaintiff, the person suing, and you don't show up, your case will be dismissed. If the defendant doesn't show up, the judge may still decide in your favor. This is called a default judgment. Step 5. After the trial, collecting your money. If you win, the judge will order the defendant to pay you. But the court doesn't collect the money for you. You have to enforce the judgment. If the defendant doesn't pay, you have legal options to collect your money, such as wage garnishment, taking money from their paycheck, bank levy, taking money directly from their bank account, property lien, placing a claim on their property so they can't sell it without paying you first. If you lose, you can't appeal unless the defendant files an appeal. The judge's decision is final unless there was a serious mistake. Final thoughts. Small claims court is designed to be fast, affordable, and lawyer-free, but it still requires preparation. Make sure you file correctly, serve the defendant properly, and bring strong evidence to court. And remember, this is not legal advice, just general information to help you navigate the process. If you have specific legal questions, consult a licensed attorney.